Board members, this is Patrick Fife here to provide you an overview of the New York City Fairness in Apartment Rental Expenses Act, also known as the FAIR Act. The FAIR Act applies to all residential rentals and leases in New York City starting on June 11th, 2025. The FAIR Act does not apply to the rest of New York State. Its scope and applicability is limited strictly to residential rentals and leases in New York City. That's any of the 5 boroughs. The FAIR Act provides certain broker compensation rules. First, landlords' agents cannot collect from or impose any fees on tenants. Landlords' agents must have a compensation agreement with and receive their fee directly from the landlord. Similarly, brokers' agents are also prohibited from collecting any fees from tenants. Any compensation due to a broker's agent must be paid by the landlord. The FAIR Act also has co-broke restrictions. No co-broke arrangements are allowed where a tenant's agent shares their compensation with a landlord's agent. Tenants' agents can be compensated directly by a tenant under the FAIR Act. So brokers can collect fees from tenants if they are hired by and acting in the best interest of the tenant. While not required under the FAIR Act, tenants' agents should have a written agreement with the tenant specifying the compensation due by the tenant. That agreement can be either exclusive or non-exclusive. Dual agency is permitted under the FAIR Act. However, a landlord must still pay their agent directly. A landlord's fee cannot be paid by the tenant in a dual agency situation. Informed consent is required in the case of dual agency. In addition, consent is required from both the landlord and the tenant if the broker is paid separate fees by each for the services rendered to the landlord and the tenant. The FAIR Act also has certain fee disclosure requirements. All listings must clearly disclose any tenant fees. Before lease signing, landlords or their agents must provide the tenant an itemized written disclosure of all fees and include a short description of each fee. This disclosure must be signed by the tenant prior to signing a lease, retained for at least 3 years, and a copy must be given to the tenant. The FAIR Act will be enforced by the New York City Department of Consumer and Worker Protection. There are significant penalties for a violation of the FAIR Act. Landlords' agents collecting tenant fees can be fined up to $1,000 for the first violation and up to $2,000 for subsequent violations within 2 years. A failure to provide an itemized disclosure can result in a $500 fine for the first violation and up to $1,000 for subsequent violations within 2 years. Civil actions can also be brought by any person alleging a violation of the FAIR Act. If you have questions about the FAIR Act, please reach out to LIBOR's Legal Support Center, which can be reached at 631-661-4800, extension 335. A reminder that the Legal Support Center offers LIBOR members free exclusive access to a qualified attorney who can provide information on real estate matters. It's available Monday through Friday, 9 a.m. to 5 p.m., excluding holidays.